If somebody dies without a will, we need to first determine what they have in their estate and who's it going to go to. There's a couple of ways to look at that. First of all, I would say make sure you don't have a valid will. Check the safety deposit box, check the documents. I mean, people file these things in the weirdest places, and a lot of times they'll get them done and just stuff them away to keep them safe. They are safe, we just don't know where they are. So spend the time to make sure that there is or isn't actually a will available for you. Then if they do just die, and we're over here for the after death transfers, there's a couple of ways things can transfer. If they have a joint account, a designated beneficiary, a POD or TOD, which is a payable on death or transfer on death nomination, joint with right of survivorship, life estate, community property agreement, these are sort of flop transfers, which means you don't really have to do much. The person that was named already gets the stuff without too much effort, okay? If there isn't a flop sort of nomination on there, then we go through the procedural sort of effort of transferring assets. If you have real property, whether it's a tiny little piece of dirt or a really big piece of dirt, doesn't really matter, or a certain amount of money, you're going to go through probate, whether you have a will or not. If you don't have a will, the state's going to give you their version of a will, which may not be what you want. It's going to tell you who to give the assets to and how much everybody gets, which is why having a will is a great idea, because you can decide who's in charge, who gets what, and how much they get, and how it's going to be delivered, whether in person or into a trust. The probate process is regulated by state procedure, and so there's not a lot of wiggle room. There's definitely steps that you have to take. It's not as scary as everybody makes it out to be. We're not California. They do have a great process down there, but it seems to be a bit more cumbersome than what we have up here. Ours is more of a fill out the form, file it procedure, maybe check in with a judge, but rarely do you ever have to go to court or speak to the judge about anything in particular. If you don't have real property or you're below the limits that you're needed for in terms of cash, you can go through a trust administration if you set up a trust. But again, a trust administration, you basically follow the same sets as a procedure, as a probate, excuse me. But it's one of those where since it's a trust administration, not everybody is necessarily aware of all the steps that you are or aren't taking. Like giving notice to creditors is often sometimes that gets skipped, which is why the probate process, again, can be really, really helpful. If you have no real property or less than that certain amount of money, the small estate affidavit is a great tool just to transfer assets, to say I'm representing the estate, I'm going to get what I can that was in my parents' name or my siblings' name or however that's working, and I'm going to divide it equally amongst the beneficiaries. So that will allow you to skip probate as well. A lot of it does just simply come down to what is in the estate and whether there's some flop language attached to it or not. And if not, you need to make a determination of whether it's real property or over a certain dollar limit.